You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance Team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues. Consumer protection laws and regulations impact every dimension of business. Aggressive federal and state agencies are getting the attention of senior executives who are concerned about risk management, compliance challenges, and high-profile governmental inquiries. Holland & Knight's Consumer Protection Defense and Compliance Team has the experience, knowledge, relationships, and platform to effectively work with our clients to address these issues.
Welcome to our fifth podcast of Clearly Conspicuous. As we've noted in the previous sessions, our goal in these podcasts is to make you succeed in this aggressive current regulatory environment, make you aware of what's going on with both federal and state consumer protection agencies, and to give you practical tips for success. It's a privilege to be with you today. Today we talk about the FTC's aggressive effort to limit employment agreements in all industries and for all workers. The topic is the FTC's proposed rule to ban non-compete clauses in employment agreements. Last month, the Federal Trade Commission issued a notice of proposed rulemaking concerning the FTC's initiative to prohibit employers from entering into non-compete clauses with their workers. The rule would extend to all workers and would require companies to rescind existing non-competes within 180 days of the final rule. For purposes of the rule, non-compete provisions include explicit and de facto non-compete agreements. This includes non-disclosure agreements written so broadly as to effectively ban working in the same field post-employment, as well as clauses that require paying unreasonable training costs if the employment terminates within a specified period. The stated intention behind the proposal is to benefit workers and encourage competition, according to FTC Chair Khan. About 1 in 5 Americans today, 1 in 5, is bound by a non-compete, with the figure soaring in certain industries up to 45%, for example, in tech. Any change to existing law would have broad and sweeping business impact. It affects all industries. Every company that has non-competes with employees, with the exception of companies that want to prevent an owner or partner who is selling a business from immediately re-entering the field, which would be exempt under the proposed rule. It matters. The proposal, if implemented as proposed, would bar employers from entering into or enforcing non-competes with employees or independent contractors, while also requiring companies to nullify any existing non-competes within 6 months. Adoption of the rule could have wide-ranging consequences, from fueling more trade secret litigation to altering the dynamics of pay negotiations for top executives and key employees. You can submit a public comment opposing this proposed rule. So some questions for you to consider are: first, do you wish to consider submitting comments only on your company's behalf, or do you wish to consider joining in the comments with other companies? Second, do you wish to focus comments based on issues specific to your company, issues specific to your industry, or issues specific to particular aspects of the rule or the FTC's proposed alternatives? Third, with respect to the rule, are there particular aspects of the rule that you wish to address? Fourth, with respect to the FTC's proposed alternatives to the rule, are there aspects of the alternatives that you wish to address? And then finally, do you want to challenge the rule in the comments? There's a variety of legal arguments to challenge the proposed rule, and you may want to take a look at the FTC Commissioner Wilson's dissenting opinion against the rule. So here are the key takeaways. Your ability to have non-compete clauses in your employment contracts may end. Comments are very, very important. Please let me know if you'd like to discuss or if you'd like to speak about me and the team to coordinate any comments you may wish to provide. Stay tuned for further programs as we identify and address the key issues and developments on these issues. I wish you continued success and a meaningful day. Thank you so much.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.